Hello Michigan Realtors, and welcome back to The Letter of the Law, a monthly video series designed to provide a primer on various legal issues impacting your industry. I'm Brian Westron, and today's legal primer will be on the topic of earnest money deposits. Now, since the beginning of the Michigan Realtors legal hotline in the late 1980s, the number one topic has always been earnest money deposits, or EMDs. In this legal update, I will address the most frequently asked questions about these EMDs. First, neither the law nor the Code of Ethics dictates whether the listing office or the selling office must hold the earnest money deposit. Traditionally, the EMD has been held by the selling office, but this is not legally required. Regardless of which office holds the EMD, the role of the escrow agent is a neutral one. If, for example, a buyer's broker acts as the escrow agent, the buyer's broker still has a duty to disclose to the seller if the EMD check bounces or if there is another problem with the EMD funds. Now, when a transaction is handled electronically, realtors occasionally do forget to collect the EMD. Realtor offices should implement procedures designed to prevent this from ever happening. If there is any problem with the EMD, the broker should notify the seller immediately. Otherwise, when the buyer defaults under the purchase agreement and the seller discovers that despite what it says in the purchase agreement there is no EMD, the seller may well demand that the buyer's broker pay that EMD to the seller out of his own pocket. A seller and a buyer can agree that someone other than a broker hold the EMD. Now, if a third party, most often a title company, holds the EMD, that escrow agent is not subject to the occupational code or the rules on handling the earnest money deposit. If a title company is to hold the EMD, a realtor's responsibility is to simply deliver the check to the named escrow agent within 2 banking days of receiving notice of acceptance by all parties. If a realtor holds the EMD, then the realtor must comply with the following rules governing that earnest money deposit. First, a salesperson cannot wait until there is a binding contract before turning the EMD over to his or her broker. The occupational code requires that the salesperson turn over the earnest money deposit check to his or her broker upon receipt. That's upon receipt. Second, the broker, on the other hand, is not required to deposit this check into its trust account immediately, but may hold the check until the purchase agreement is accepted. Third, a broker must deposit the earnest money deposit in its trust account within 2 banking days after the broker has received notice that there is a binding purchase agreement. A seller or buyer cannot agree, for example, that the EMD check will not be cashed until the inspection contingency is waived or until the short sale lender signs off. If the seller and buyer wish to agree to such a provision, then a title company or someone else will need to hold on to that earnest money deposit. Now, if the transaction falls apart and there is a dispute over the earnest money deposit, the EMD must remain in the broker's trust account until both the buyer and seller have agreed in writing or there is a court order directing the disbursement of the earnest money deposit. The real estate licensee can also interplead the funds with a court. Now, this rule prohibiting the broker from dispersing the earnest money deposit only applies when there is a dispute over the EMD. If there is no dispute, the occupational code permits a licensee to release the EMD without a signed release. If there is a dispute over the EMD, a realtor cannot release the funds even if either the seller or the buyer are wrong about there being entitlement to the EMD. The rule that permits the release of the EMD without a signed release only applies in the absence of a contractual provision to the contrary. Some realtor purchase agreements provide that if the transaction fails for any reason, the EMD will not be released without a signed release from both parties. If the parties' purchase agreement contains such language, then this is a contractual obligation which must be adhered to. Also, a realtor cannot condition the release of the EMD on the seller's or buyer's agreement to release the realtor from all liability in connection with the transaction. And a purchase agreement may be deemed terminated even if there is a dispute over the earnest money deposit. Ordinarily, the fact that there is a dispute over the earnest money deposit does not prevent the sellers from relisting or the buyers from looking for a new home. On the other hand, if one of the parties insists that the purchase agreement is still enforceable, a realtor should always advise his or her client to consult with an attorney. Realtors are not entitled to keep abandoned earnest money deposits. Rather, the funds must be turned over to the state of Michigan. Realtors have an obligation to report unclaimed earnest money deposits after 3 years. A failure to do so can result in the broker having to pay significant fines. Now, as a final consideration, it is not always the case that a buyer can walk away from a transaction with no adverse consequences other than the forfeiture of that buyer's EMD. Many purchase agreements provide that in the event the buyer defaults, the sellers may keep the buyer's earnest money deposit and sue the buyer for damages. If a realtor is advised by buyer clients that they wish to get out of a purchase agreement, the realtor should advise them to consult with an attorney about the ramifications of doing so. As always, thank you very much for tuning in and watching this legal video primer. If you have questions or would like to suggest topics for future videos, please send those suggestions to the email below. These suggestions have been very helpful in formulating the topics for the last two, and I look forward to hearing from you soon. See you next time.